these are the difference. I just want to slightly show you the difference between the mediation under the district court and the mediation under the RGR or under the arbitration and RGR law number 30, 1999. For the district court, the institution is district court located in each regency and cities in Indonesia. In RGR, there is non-institution based, or we have here the institution of mediation center. We call it PMN, Pusat Mediasi Nasional, or Indonesian Mediation Center, or in BANI, Indonesian Arbitration National Board, because in BANI is actually arbitrations, but the arbiter will encourage the party to enter into mediation and settle amicably. And the durations basically almost the same. The mechanism in the district court, 30 days. It can be extended for another 30 days. But a typical mediation in district court, straight away 30 days. If there is no development, if there is no settlement between the parties, then the judge will cut the process and continue the proceeding. Yeah? And in RGR, the period is 30 days. And the mediation fee in the district court, we have two types of the mediator. The first is non-judge mediator. So the parties agree to use non-judge mediator. If the parties agree to use non-judge mediator, of course there will be a separate fee to be agreed by the parties. But the second type is that the mediator will be the judge. Yeah? And if the parties agree to use the judge, yeah, as the mediator, there won't be any additional fee for the mediators for the mediation process. In the RGR, it's private mediations equally, and practically the fee are calculated based on hourly basis. Yeah. For example, in the PMN, Pusat Mediasi Nasional, is provisions that the minimum mediator fee is for $2.5 million per hour, which is about $160 US. Yeah. Mediators in RDR is institutionalized or as agreed by the parties. In a court, it can be judge or it can be other certified parties. So the key is as long as the mediator is certified mediator.
I hate the dispute resolution practice, which means that I resolve disputes. Having done this, and I do quite a bit of cross-border disputes, having done this for a long time, I fully appreciate from the commercial man's perspective the need to work out the most quickest, cost-effective way to resolve dispute rather than on all occasions getting judgment published so that interesting propositions of law can be ventilated for the benefit of lawyers. Now, this is where mediation comes in. I am a true believer of the benefit of mediation, and I'm seeing an increasing number of cases which are now settled through mediation in Singapore and through SIMC. Now, mediation, at the very least from the Singapore's perspective, has taken a significant seat as an important dispute resolution mechanism and no longer seen as a poorer cousin of arbitration or litigation. Now, the significance of the acceptance of mediation as a serious tool for dispute resolution is evidenced by the introduction of the Singapore Convention on Mediation.
So, my name is Tomoki Yanagisawa. I'm a lawyer in Tokyo, Japan, and thank you for having me on this panel. So to answer your question, so in Japan, mediation is not mandatory to commence litigation, save for a very limited exception, which is the rent review case. So the short answer is no. And I will also mention that under the law, court has discretion to refer a litigated case to a mediation if it deems proper, and that often happens in the field of construction or other, say, some medical malpractice cases that involve technical knowledge. But on any other, I would say, commercial disputes, it's rarely that the case will be mediated.
In Korea, mediation is optional, except for family court. The family court, you have to do the mediation first, but the other commercial matters is only optional. However, in the past, Korean courts lay a judgment quite quickly, but during the last couple of years, it's a delay. It's getting longer and longer. So we have a lot of a need for the mediation as a quick solution of the case. Let me give you some idea. Let's say the judge will think that this case can be mediated easily, then he refer the case to the mediation. And then judge does not intervene any of the mediation process. So separate mediator run the process. And about 25% have a successful rate of a mediation. So entire case, 20% is referred to the mediation. Among them, 25% is the successful rate. So entire big picture is not that big portion, but still we believe there's a huge potential. So there are a lot of activities going on in South Korea because we need mediation more. So as an infrastructure, there could be a legislation, there could be some education and training program. I learned a lot from Indonesian practice.
In India, as the country is developing, so they are very open to having pre-litigation mediation. So as in 2015, there was a judgment whereby the Supreme Court directed that there should be pre-litigation mediation desks in all the court annex mediations. So we have two kind of court annex mediations. One is when you go to the court and the parties are before the court in a court case, and then the matter is referred to mediation. But there are other cases where the parties just approach the mediation center, which is next to the courts, and they put their cases before the mediation center. Each mediation center has a panel of mediators. So the parties are not open to choose their mediators, but the mediation center, which they think appropriate on the subject, and then the mediation takes place. Whenever a settlement is arrived at in this mediation center, there is a stamp of the court, and in this pre-litigation mediation, the enforceability is not difficult because it has a stamp of the court. And sometimes the other court annex cases, as Mr. Lee just said, that the matter goes to the court and the matter is sent for mediation. That is the other way of doing the cases. There also, there is a stamp of the court. So the execution is not a difficulty.
Yeah. Perhaps I have to tell you that in Korea, we have a lot of dispute resolution centers. The government agencies and ministries wants to set up a dispute resolution center a lot. Some people even criticize that there are too many. In fact, some dispute resolution centers simply do not have many cases.
Please, Mr. Yanagisawa, how about in Japan? How do you see the trend of mediation, or the industry or the business sector that now use mediation as business dispute resolution tools?
Okay, so I guess in terms of sector side, it's important to distinguish whether the mediation is used as a way to resolve B2B disputes or more like a B2C consumer type disputes. And in that regard, I think the most predominant sector which uses B2B mediation, so to say, that would be construction, as I mentioned earlier. So in fact, there is a government established adjudicatory body called the Committee for Adjustment and Construction Work Disputes, and which handles, it provides mediation services as well as arbitration services. And approximately, statistics say about 100 cases a year that they handle and resolve. In terms of B2C type of disputes, I would say financial industries, they have some government or quasi-government-backed ADR centers which handles mediation.
So what the clients were doing is, they were not trusting me effectively. They were not thinking that if I may think that they may be prepared to show some concession. They may be prepared, if I may be misunderstood, I may misunderstand, they are willing to compromise and take it as a form of weakness and compromise their case even further. So they want to give me the impression that they don't want a concession so that I will do my job as a litigator 100%, even though there is a risk that they may well end up losing a lot more. But they were not prepared to tell me that they were even prepared to compromise even 1%. They just wanted to give me an impression that they want to fight 100% so that I will do my job 100%. So is that something which is normal?
Well, yeah, that's an interesting experience. Well, small or large, I experienced a similar situation as well in a domestic mediation. But I think we have to approach in a two-way. Number one is that Korean people are highly concerned about what they look like to others, how others look at you. So if they make a concession, means that, oh, I did wrong, that's why I made a concession. So they want to avoid that.
Okay, so I think the situation is somewhat similar to Korea in a sense that Japan has not utilized mediation as at least a predominant common way to resolve business disputes. So in that regard, one, we need to explain what the process of the mediation, what's likely to be achieved, what are the benefits, and more importantly, we need to set up an infrastructure. In Japan, we established a Japan International Mediation Center back in 2018 in Kyoto, near a temple to temper keep people calm down and have a nice way to make conversation. But not just the infrastructure, but all equally crucial are the trained mediators and counsels advising on mediation. So those are the things that Japan is now working on, and I think I also agree, and I'm hopeful that mediation becomes a useful way to resolve cross-border disputes.